Hello, my name is Bob Joseph. It's my pleasure today to chat with Alan Silberman, who's been a close friend and colleague of mine at the law firm of Sonnenschein, Nath, and Rosenthal since I started with the firm in 1976. Good morning, Alan.
Morning, Bob.
You've been a distinguished antitrust practitioner for many years. What was your first intersection with the subject of antitrust? What incited you to become interested in antitrust?
Well, it really wasn't so much antitrust as it was understanding government and how government dealt with complex facts, which started when I was in college with a professor who got me involved in working in the administrative process and encouraged me to start writing and doing independent writing and thinking. And then when I went on to law school, I had, at Yale, I had exposure to Bob Bork and Ward Bowman, who
two giants of antitrust.
Giants of antitrust, but Bork, the lawyer, Bowman, the economist. And what I learned from that was the intersection of economics and law, but also a sense that economics, while very important, was just a tool. It was another complex fact. And ultimately, what that pushed me toward was a sense that I wanted to try lawsuits, I wanted to be involved in the courtroom, but I wanted to be involved in a process where we could take complex ideas and simplify them and get them down to the core, to the real principles. So that's where I started on the antitrust road, not yet calling it exactly antitrust.
Okay. But before you entered private practice, you had a clerkship with Hubert Will, a federal district court judge in the Northern District of Illinois. I think it's fair to say that Judge Will was well known for participating in early plaintiffs' antitrust actions while he was in private practice, and for supporting private antitrust actions when he was on the bench. Could you tell us about your experiences with Judge Will, and particularly how it impacted your view of antitrust law and policy and practice?
Like any young lawyer, I thought I could teach the judge, and I understood antitrust as a highly cerebral enterprise, and I thought I was really teaching Judge Will antitrust, and I got away with it a little bit until one day when he let on to me that his father was a drugstore owner in Milwaukee, Wisconsin, and hated fair trade and hated the restrictions that were put on him by manufacturers. And then I began to realize that there was this populist side to antitrust, and that if you were going to try lawsuits, not only did you have to get the law right and the mind right, but you had to get the facts presented in a way that would make sense to ordinary people, and the judges were ordinary people.
And then after you clerked for Judge Will, you came to the Sonnenschein firm, I believe, in 1966. When you came to Sonnenschein, did you think you were going to be practicing antitrust law? Did you want to practice antitrust law? How did all of that develop?
I told the firm I wanted to practice antitrust law, and first couple of months there was no opportunity to do that. I did some other things. I was lucky and succeeded in whatever had been assigned to me. And then Earl Pollack, who was the head of the antitrust practice and a giant in antitrust law, Earl said, "I hear you want to be involved in antitrust." I said, "Sure." And the next hour, a bunch of workers came and brought me the 100 volumes of the record in U.S. versus Arnold Schwinn, and he said, "Well, you now have a case in the United States Supreme Court. Only you don't get to argue it. I get to argue it." I said, "Okay, that's a deal," and that's how I really got first involved in antitrust.
Well, you got involved in a very important matter where the Supreme Court decided that customer and territorial restraints that were vertically imposed were nonetheless per se illegal, which is no longer the law. What did you do on the Schwinn case? How did the issues in Schwinn affect you? Was it seem strange to you?
Well, I worked hard on writing the briefs. The people involved in Schwinn, by the way, are fascinating because on the government side, it was Dick Posner arguing. Joel Davidow was his second chair, Earl and me, and Bob Keck also was then Keck Mahan. And I spent a lot of time writing. At the argument, I kept passing notes up to Earl during the argument, and he kept crumpling them, and I kept seeing my career falling apart. Happily, that didn't happen. What did I learn? Nobody ever thought that the great principles of the Sherman Act turned on the ancient rule on restraints on alienation. In one sense, that tells you that judges don't always get it right. Even Supreme Court justices don't always get it right. But in the long run, what it told me was that we had a very poor record understanding what the ultimate impact of an antitrust decision was going to be. Because in the Schwinn case, applying the ancient rule against restraints on alienation meant that if you sold by consignment, you could restrain territories and customers. So Schwinn said, okay, we'll take the independent wholesaler out of the picture. And ultimately they did. A whole group of independent businessmen lost their businesses lawfully because Schwinn was complying with the ancient rule against restraints on alienation, which would apply if they dealt with an independent businessman, but would not apply if they sold direct. So nobody thought that that would be the outcome, and the outcome is really not very good for the economy, not really very good for antitrust, and of course 10 years later it disappeared. Interestingly also, 10 years after that, Schwinn, who had kept on with this very restrictive distribution system, Schwinn didn't anticipate the growth of the big boxes, the discount stores, and so on. And so ultimately, Schwinn bicycle business collapsed because they didn't adapt either. So what it gets you back to is we're not very good at figuring out what the ultimate results of antitrust enforcement are. But the one thing we have to keep working with are the facts, the facts, the facts, the facts. And the more we do that, the better our results will be.
Earl Pollack, our former senior partner and mentor, was indeed an antitrust giant and a former chair of the Section of Antitrust Law. What was it like practicing with Earl? How did you develop your own space practicing with him and develop your own antitrust niche or practice?
Practicing with Earl, and I think this is true for a number of my contemporaries who were working with people who were seen as the giants, intellectual giants of antitrust. It was a challenge. Mm-hmm. It was one of the best lessons Earl taught me when I kept trying to make a point to him, and then he would disagree, and I'd make it again, and so on. He finally said, it's not that I didn't hear what you said was wrong. You learned how to sharpen what you were saying. We had an interesting blend because Earl was a consummate appellate lawyer. He had been in the Solicitor General's office. He had been Supreme Court clerk. He loved argument, appellate argument particularly, and he did not like day-to-day trial work as much, or at least that's what he said. So the day-to-day trial work in a whole bunch of cases, the working up the details and getting immersed in all these sticky facts that I loved, became my job. And so it was a great division of labor, and it went on with happily some very, very good results in terms of cases.
Going back to Schwinn, it didn't appear that the Supreme Court cared much in Schwinn about economics. At the time you started practicing, what was the relationship between economics and antitrust policy? How did you see it at that time? Were there any interesting developments occurring at that time?
When I started practice, I think economics, the impact of economics was really rudimentary. I mean, you understood what a demand curve was. You understood that price fixing had a certain impact, but it was not well organized in terms of a tool to help understand. And it was not at all a predictive tool. It was at best another citation like you would cite, you'd cite White Motors for something. You'd cite another case for something. It wasn't until really until GT Sylvania, that economics becomes a much more important factor of how do you define relevant markets and so on.
Did you see any use for, or have you over the course of your career seen use for experts other than economists in antitrust litigation?
Yeah, actually, because of my sense that facts really ought to drive results, I early on became an advocate of marketing experts and used marketing experts either to the exclusion of economists or in tandem with economists, because the marketing expert was able to explain to a jury or a judge in real world terms why certain behaviors took place, why they made sense. And assuming you had a client who could also explain why what the client did made sense,
right,
that really worked. So I found marketing experts to be more powerful. I still find marketing experts to be more powerful because they're able to package ideas. Now, there are economists today who can package technical ideas into simple terms, but in those days, I mean, I got hung up on things like you know, R2 and multivariate analysis, and if I got hung up on these, then I assumed that, you know, jurors glazed over when they heard these
right.
things.
I recall one case involving golf clubs and pro shops where I believe you used a marketing expert. Can you give us an example of what
Right.
an expert in that case did?
Right. The expert in that case had to explain why a major manufacturer adopted a rule for selling a pro line of golf clubs and golf balls only to pro shops and not to the regular retail outlets. And it was challenged as a violation of the antitrust laws and a matter of conspiracy. The marketing expert went out and had focus groups with pros and learned that there had been problems with the product. The company involved had had some manufacturing problems. And because of the relationship with these pros and the endorsement that the pro shop people gave to the consumer, they were able to recover their market position. And so that corresponded to the testimony of the business person who said they came in, they were free to change their marketing strategy, but having analyzed where the company had been, the assessment was that by maintaining this special relationship, this image, by the way, the products were almost identical. Price was quite different.
Yeah.
But by maintaining that image and the high price, they were able to maintain their business. And the marketing expert endorsed that as sound marketing, what a company would do pursuing its own unilateral strategy to build its business and build its brand. Now, we had an economist as well, but in the end, one of the deans of the Chicago antitrust bar, Hammond Chaffetz, came up to me afterwards. He had told me I should not use a marketing expert because he represented a co-defendant, and he came up to me and he said, "I've heard the marketing expert now. You were right." And we needed the economist also, but marketing experts are a way of, and good economists today are also marketing experts.
You referred to Hammond and Earl, and there's other notables in the antitrust bar at that time. And since that time, how would you describe the practice of antitrust law at that time? What was it like? And has it changed over time?
It clearly was collegial, cerebral. People who were really involved were larger than life. They were dealing with issues and ideas that ordinarily lawyers, A, weren't dealing with, B, didn't really understand. And what was probably the most interesting was that those people generated a next generation of younger people also committed to antitrust in much the same way. So it was very exciting. There were not a lot of us, especially once you got out of Washington, or Washington and New York. So it was really a very exciting type of experience. Reflect on that today. We are having new generations, several new generations of people who are developing the same kinds of relationships and hopefully the same kind of contribution ultimately to the public forum as far as discussing antitrust principles.
You talked a few moments ago about what I'll call your cerebral approach to antitrust coming out of law school, and you were contrasting it with some of the populist concepts or ideologies that Judge Will was sort of reflecting. How do you deal with both the theoretical, economic, law and policy aspects of antitrust on the one hand, and the populist rhetoric when you're trying to develop a lawsuit and argue it in front of a jury or a judge who's a generalist judge?
It's really easy. You're just a schizophrenic. You have to try 2 or 3 different cases at the same time. You have to get involved with the facts, but you have to also know that the facts are messy. The facts are sticky. They're not going to always hold up. Ultimately, a judge is looking for a principle, is looking for something that fits precedent. But the judge is also looking, and a jury for sure, for something that makes sense. So you try to devise an approach that says, here are all the legal bases. This makes good law, but it also makes good common sense, and then the two fit together. You have to. My view is that even in today's world, where a lot of things are driven by formulae and by economic analysis and so on, or just even by quotation from cases, you still have to go back to the very basic question: is what you're trying to uphold something that sounds sensible? And then, of course, you always ask your client that question: why are you doing this?
Always a good question. Let's focus a minute on antitrust policy. I think most of us understand that price fixing and other cartel behavior reduces output, raises price. When you turn to distribution and vertical restraints, I think many people are wondering, where's the competition problem there, if at all? How do vertical restraints lead to reductions in output and anti-competitive behavior? How have you viewed this question or thought about it? Do you think vertical restraints laws developed in a significantly more positive way since you've been practicing?
Well, the first rule is to have a healthy skepticism about everything.
Okay.
Okay, so we start by saying that the per se rule doesn't apply to most vertical restraints, maybe all, and we still don't know exactly what that means. Then we switch to the other extreme, and we do copy something that Earl Pollack put forward, that is that the civil rights, the theory, antitrust law is not a civil rights law. It's not driven by the fact that a distributor says, I want to do things my way, I have a right to do them. Okay? So now we have a lot of tension here, and it moves back and forth and back and forth. So we learn that many types of what we called vertical restraints, A, are pro-competitive, B, were challenged initially only because the Supreme Court in Dr. Miles did not understand the difference between vertical and horizontal restraints. They thought they were the same, except for the dissent. They thought they were the same. So we begin to learn more and more. But the pendulum keeps swinging, because today we see that even within vertical restraints, there can be areas that are problematic. There are areas of exclusive dealing that are problematic. There are some areas of vertical price agreement that can be problematic. The real question, I think, that we now come to is, how should we address those problems? Should they be going to a lay jury? Should they be going to a generalist judge? Should they be driven by populist rhetoric that simply equates, gee, prices are higher, that must mean that's bad? Because I don't think that's either what the law intends or good policy. But
with respect to vertical restraints.
With respect to vertical restraints. Not with respect to cartels.
Right.
Cartels are clear. So the point of all of this is that there is an intellectual ferment about vertical restraints. It goes back and forth. There are cases where you can, take, for example, dual distribution, which one time was a real question in the law after fair trade. No longer. But there are new questions. And we have to approach these things in a very careful way, trying to integrate law, trying to integrate new economic learning, and now new behavioral learning.
Right. You keep coming back, I think, the consistent themes of using theory, but always having it informed by facts and by experience. You have been involved in a number of important antitrust and franchising cases. Are there any particular key developments in the law that you were involved in that you'd like to mention?
Well, I guess the first one we'd put on the top of the list would be in tying in the Kipta and Principe cases,
right.
Which are cases that actually Principe holding that McDonald's arrangement of owning a land and building of a restaurant and then giving what we characterized as the operating rights to operate within that restaurant was not a two-product tie. And then the Kipta part of that, the same fact situation, but arguing that if you were measuring antitrust injury, that you had to look at the package as compared to what the buyer would otherwise pay, and if there was fundamentally no difference, or if it was less, then there was no antitrust injury anyway. Now, why are these things good? Is that good law? Yes. It got displaced by Jefferson Parish saying, well, we'll look at market power. Except if you read Jefferson Parish very closely, it says usually called market power, and so it leaves open, again, some factual things about how we affect consumer behavior. What drove the decision in those cases was, again, factual material as to why a company adopted this program as a way of doing business. And just one anecdote from that, one piece of evidence, was a franchisee in Indianapolis, Indiana, who said, thank God that McDonald's owned the restaurant and the building, the land and the building, and therefore could get rid of a non-performing franchisee without losing the marketing locations. This person had one franchise in Indianapolis. There was a person who had several in the area, had a problem. McDonald's was able to remove that person but maintain the marketing locations so that this one individual was able to remain part of a strong marketing organization. And he said if the price of getting rid of the non-performing franchisee had been that we lost the marketing locations, I would have lost my business as well. Now, that's a very powerful story. It makes sense. It leads to a very simple conclusion, which was McDonald's was following this practice, which some people called tying, in order to be a more effective competitor in its core business, and therefore that can't be tying. Okay? Now, we don't deal with those questions as much anymore, but at that time, that was a very powerful breakthrough.
It was indeed. You've been very actively involved in the Section of Antitrust Law through large parts of your career. You were chair of the section in, I believe, 1993 and 1994, thereabouts. And it served in a number of key officer positions and on major task forces and committees. How did you get involved in the section? And what are some of the more positive memories you have of your participation in the section?
Got involved in the first place by, again, starting to write. And ended up writing or editing the Section 5 monograph. And the first thing that occurred in that was something that I just never anticipated, which was Bob Potofsky called me up. And you know, I'm a little kid,
right.
And Bob Potofsky, who may not be that much older than I am, but he's a giant, and I'm a pygmy. And he says, "Can we chat?" Sure. And we met in the Shoreham Hotel during one of the spring meetings, and he was very concerned as to the direction of this monograph and what it would do in terms of the future of the Federal Trade Commission. And I suddenly got to the realization that somebody thinks that what the antitrust section of the American Bar puts down in writing is really important, and it can really have an effect. Well, that was fascinating. Through the section, you got to meet a number of people, colleagues, who were bright, active, thoughtful, and then we kept working on various projects. But I think the ones that I'm most interested in was, by the time I became chair and thereafter, was beginning to just the beginning of reaching out internationally and talking about international cooperation. And I remember going to Brussels and giving a talk where we said we're gonna move slowly toward harmonization and toward coordination, and at some point the old world is going to begin to influence the new. Now, it's taken something like 20 years for that to happen. But you see how, for instance, European concepts of being concerned about dominance, being concerned about other kinds of behavior, have begun to influence some of the ways we look at antitrust issues in the U.S. And conversely, we see how economics, which was developed more forcefully in the U.S., have begun to influence Europe. I'm very happy to have been right at the start of that, and also to have worked on one of the earlier reports to an incoming president about advice for issues for antitrust. And again, all of this indicated that people really do listen to the Section of Antitrust Law.
And you also, I believe, were a member of the so-called Kirkpatrick II group, which had been studying the role of the FTC and possible improvements at the FTC. That, again, a fascinating group of people, and a process which encouraged a lot of free thinking. I ended up coming up with a little additional comment. I didn't want to call it a dissent because it really wasn't a dissent, but suggesting that we really could and should strengthen the Federal Trade Commission even more, that if we were really serious about the early conception of what the Federal Trade Commission was supposed to be like, we should be giving it responsibility to deal with some of these sticky questions in a more measured way, measured in the sense that you would not have private rights of action, and we would have to make sure that we had no private rights of action, and that the relief was prospective only. It was not a matter of damages, but in terms of making judgments that would affect the way business operated and gave businessmen the kind of clear indications that they need to plan their business. Those were all things that required strengthening the Federal Trade Commission, placing criminal activity, cartel activity in the domain of the Department of Justice, and that was So you've had an interest in thinking through the law enforcement aspect, the structure. Did that come out of? I think you once mentioned to me that you were took political science courses, and you got interested right early on in the administrative process. Do you think that's incited that ongoing interest in it?
Yes and no. I mean, certainly, I became a believer in the administrative process, not to the exclusion of the courtroom and not to the exclusion of generalist litigation, but as a means of identifying and exploring issues and illuminating them and then packaging them properly. On the other hand, I also was able to understand the limits of the administrative process. The one problem that I saw all the time was that once you begin regulating, you want to make everything be as neat and simple as you can so that you can regulate it. So you begin to ignore facts. You say, that fact's not relevant, that fact's not relevant. I want facts that I can line up on a nice chart, and then I can measure 9.2 on this, 3.5 on that. So there's a limit to the regulatory process as well. And what's the bottom line on all this? We live with this tension. It's not a bad thing. It's a good thing. It's what makes antitrust so exciting, is that most of what we're talking about will be unresolved and probably unresolvable, but we're going to keep going, working in what we think is the right direction. My only hope is that we circle back every once in a while and say, what did we lose en route by all of our emphasis on economics and formulae and things of this sort? Did we lose something else?
Right.
And how do we put that back?
Right. Alan, we've been discussing your antitrust practice. You also have considerable expertise in franchising and distribution law beyond antitrust, where there may be issues other than antitrust issues. Could you explore for a moment the similarities and differences in giving advice and in litigating issues in those two respective areas, and in any synergies that may exist between the two?
At one point in franchising and distribution, the only real legal issue that was around was antitrust. We spent all our time talking about Schwinn and then GTE Sylvania. What you learned in all of this, as you start working with clients who are involved in franchising and distribution, what you learned is that the public issue is quite similar. Public issue is what role does each party in the distribution system play, and when do we get concerned about what, for want of a better word, I'll call arrogance? Now, there's economic arrogance. It appears in the antitrust laws. It may extend all the way to cartels. But there is another kind of arrogance as well that disregards the interests of people in the distribution chain. Or conversely, someone at the bottom of the distribution chain being arrogant and saying, I can decide everything for myself. I don't need someone telling me, why don't you just give me the flour? I'll put the flour in my own package.
Right.
Why do I need a brand? What's the power of the brand? So you have all the same kinds of issues, and the process for talking through them starts exactly the same way with the same question. Why do you want to do this? What is the objective? How do you explain it to someone? How do you explain? How do you explain why you have, well, take one place where it comes together. I had a client who had developed a new product at some considerable expense and decided that the way to go to market was to create this very high price image through a limited number of retailers and to encourage them to keep the price high. Okay? That would establish the brand and the quality and so on. Okay? So you have to work through, what did you do? Why are you doing this? How do you express it? Right? How do you avoid the antitrust problem of you don't want to have a price agreement, but how you want to say to someone, this makes sense to us, we hope it makes sense to you, it's ultimately your decision, but we think you should spend some time thinking about this. We hope you will. There's a way to present that. There's a way to train people to that. So you're asking the same question on both the antitrust side, why am I trying to have an impact on price? On the distribution side, why am I trying to set up a distribution network in a certain way? All of it is client-centered. All of it, and that probably is the common thread. That is, when you're dealing with this kind of activity, whether you call it antitrust, whether you call it franchising, whether you call it just distribution or marketing law, you are dealing with clients who have objectives. You are dealing with customers who have objectives. How do you deal with those situations? So the whole thing fits together.
It indeed does. You've been a counselor and a litigator, and what have you seen as the advantages of doing both?
Well, as you know, this has been an article of faith for me. That is, that if you try lawsuits, you'd better learn something from your experience in the courtroom and be able to talk to other
It's a pretty good laboratory.
people about them. So you'd better counsel.
Right.
If, on the other hand, if you're counseling, you darn well better be able to defend what you just said in court.
Right.
So I think the two do go together, and with it goes a heavy dose of transactional involvement, because in the end, we're always dealing with words. And the question is, will the words have the impact that I want them to have? What do I have to have in an agreement? What do I have to have in terms of clarity of language so that I will address issues that will pop up later in the courtroom? And so you fit all of that together, and that makes, again, for a very interesting practice, very exciting practice.
You've done a lot of writing. Why? What have you learned from it? What advice do you have to younger lawyers who are considering writing?
I was encouraged to do a lot of writing from the very beginning, and probably at the beginning wrote too long, too much. Had a law review article that was 140 pages long on price discrimination, and
that is long.
On the price discrimination and the antitrust laws. And in fact, I mentioned at one point to Fred Kahn, I said, Fred, I don't understand. You're called the father of deregulation.
This is in airlines.
Yes, on the airline industry. Yeah. You're called the father of deregulation. I published before you. And he said, yes, but nobody reads a 140-page law review article.
Right.
So you learn that you got to be very careful. And you have to, I then moved the other way to try to write things that were simpler and pithier. And there's a balance between the two. So what do you learn from all of this? What you learn is to research long and try to write short. And you'll learn a great deal. The other rule that I have applied is I have almost never, used an associate in the law firm to do research for anything I was writing. I've always done it myself, because I learn a great deal in that process. 80% of that does not end up in the finished product. And that, I think, is a key part. The writing is part of learning.
What about your extensive CLE participation, which not only involves writing, but the presentation? Do you have any ideas on what makes for effective oral presentations, panel presentations, teaching?
Just do it, and it gets refined. Periodically, I find that what I'm doing doesn't resonate with the audience. And you've got to, just like I said, you should be skeptical about the law. You got to be skeptical a bit about yourself.
Right.
And you have to revise and redo and recognize that sometimes people are not taking away the message that you want. What I've learned on that is writing and talking in multi-levels. If you look at the CLE materials that I do now, you have a paragraph at the beginning. Let's take vertical price agreements. It says, in a nutshell, ding, 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 ding. There's maybe 3 paragraphs. Then it says, new developments, hot topics. All right. Then we start to unpack it. Okay. Now, it'll go on for many, many pages, organized so that you can find citations and things of that sort. But what I've learned is that that's no different than a good oral argument. And the goal here is to communicate with your clients, communicate with the court, communicate with a jury. It's all the same skill. The real problem today for the lawyer who wants to start out is that you don't get the kind of opportunities that you did 40, 50 years ago. Well, I've only been doing this for 45, so 45 years ago.
We won't get you to 50 yet.
And that's a problem. That's a real problem. I don't know how you solve it.
You've often referred to antitrust as a living tree, and I think many of the points you've made today indicate that. But do you want to expand upon that? And is it a good thing, or are we just growing weeds because we don't know what we're growing?
It's a good metaphor.
Okay.
It's a good metaphor. Think about it in the following way. First of all, the tree has to be pruned periodically. Second of all, the tree has to be fertilized with new ideas. You can't just say, ultimately with the tree, you have to take out the oldest branch.
Right.
That'd be really hard in antitrust. But you've got to fertilize with new ideas, with new things. Things will grow up from the bottom. Not all of them are going to develop branches and flower, but some are. And we have to be willing to accept that. We have to be willing to accept the idea that, particularly in antitrust, where we are dealing with an economy and a society that changes,
Right.
that the law is going to change. I love the law I learned in 1967. It made such wonderful sense to me then. Some of it continues to make sense. But ultimately, we're going to go back to balance the kind of open-ended inquiries that involve rule of reason cases with the need to have guidance and definitive guidance for business people and judges. And ultimately, we have to face, I think, a line that I learned in one of Posner's opinions. It's either Posner or Easterbrook, so I'll give them both credit. But it's if everything is relevant, nothing is determinative.
Right. Right.
So you've got to balance all this stuff. It's like gardening.
It is indeed. And so, what would you tell somebody who wants to become an antitrust gardener in 2010 about antitrust practice? Have any advice?
Listen to everything we've just been saying. Fasten your seatbelt. This is going to be a little bit of a bumpy ride. It's supposed to be a bumpy ride. Get involved in the facts. Get involved in theory. Try to figure out how they mate. Every once in a while, you'll come up with something. And ultimately, try to find other people who you can talk to about this. Because you can read all you want to. But some of the most exciting discussions, some of the better insights have come sitting with your colleagues, not trying to win a case, not trying to write a brief, but just saying, what is this all about? Or what does this really mean? Or how can this be market power? And having these kinds of discussions and tapping into other people who, like you, are committed to the search for making this area of the law more effective, more rational, and ultimately more satisfying.
Well, Alan, it's been a real pleasure. Being able to ask you questions, and I've heard much of what you've said before, but this brings it all together. And I think those who are listening to this tape see your impressive ability to think about theory and facts at the same time, and to hold them in balance and tension, which leads to great creativity. Thanks so much.
Thanks.
Okay.